I, Sakshi Narayan, on behalf of IIMT College of Management, welcome you all in the 7 days Faculty Development Program, Entrepreneurship across dimensions, innovation, finance, and intellectual property. Today's topic is intellectual property rights in India, patents, trademarks, copyrights, and design, which will offer valuable insight into creating sustainable, competitive, and scalable business models in Indian entrepreneurial ecosystem. To enrich our understanding on this topic, we are privileged to have with us a distinguished academician, Dr. Tanvi Sharma, whose expertise and scholarship perfectly align with today's session. Allow me to introduce her. Dr. Tanvi Sharma is an accomplished legal scholar currently serving as an assistant professor of law at MIT University, Noida. She brings with her over 7 years of rich teaching and academic experience across reputable higher education institutions in India. Prior to her current appointment, Dr. Sharma has served as an assistant professor at GIMS Engineering Management Technical Campus for more than 6 years and has also been associated with Alliance University Bengaluru, thereby gaining diverse academic exposure across institutions of national repute. Dr. Sharma's area of academic interest and expertise include legal research, constitutional law, and allied areas of legal studies. She is actively engaged in scholarly research and has contributed to academic literature through publications with reputed publishers. Her published work reflects her commitment to addressing contemporary issues related to law, justice, social institutions, and environmental protection. As an educator, Dr. Sharma is known for her student-centric teaching approach, strong research orientation, and dedication to academic excellence. She continues to contribute meaningful to legal education through teaching, research, and academic engagement, making her a valuable resource for the faculty development programs and academic deliberaties. So I welcome Dr. Tanvi Sharma ma'am in our session to give us insights on intellectual property rights. Welcome ma'am.
Thank you so much. Thank you so much, Sakshi ma'am, for the elaborate and detailed introduction. And thank you so much for inviting me. If you allow, I'll share my screen. Okay. Okay. The topic which is allotted to me is with regard to intellectual property rights. And I hope I do justice towards the topic. So if I start with intellectual property rights, there is a word called property involved. Whether my screen is visible. Okay. Yes. So basically, intellectual property rights. When I talk about intellectual property rights, there's a word called property inside, and property is eventually divided to tangible property, intangible property. Tangible things which you can touch. Example, movable property or immovable property. Intangible property, one such example is intellectual property. It can be with relation to patents, it can be with relation to copyright, it can be in relation to trademark designs. There are basically eight legislation or 8 acts in India which are functioning with regard to intellectual property. And if I basically start with IPR, it is eventually divided to patents, it is divided to copyrights, it is divided to geographical indication, it is divided to trademark and industrial design. Now, it is an exclusive right, which is so everything which we think of creating or innovating or invention, we think of an idea. That idea has to be protected clearly. Therefore, that is how intellectual property as an aspect comes into picture. And it is an exclusive right allotted to a person with regard to the creation of the mind. The invention eventually created by an individual has to be clearly protected for a significant period of time. And it is of course a legal right. It is an intangible asset which has to be protected in the eyes of law. Me being a part of legal industry, I would definitely encourage every innovation, every invention to be clearly protected under legal formalities. And it creates a monopoly over, or monopoly or ownership over that particular right of creation, that particular product or any kind of innovation, etc. And it also prevents other people to use the intellectual property per se. And it is an intellectual property rights has been recognized in the entire world altogether. And a product particularly, or a service particularly, generally intellectual property is granted with regard to a product and with regard to service also. So it is has gained a lot of importance these days, especially when there's a new concept of startups, which India has started recognizing after 2016, when Prime Minister Modi announced in the Independence Day speech, in order to give importance to entrepreneurs in India. We have a strong concept of intellectual property connected to startups eventually. And we have a Startup India policy, which is empowering all the startups and also helping the founders of the startup to protect their innovation. Uh, it is very important. It provides an incentive to every individual for new creation. It is acting as a tool to encourage other people to get involved in innovation, to get involved in new creation. Because a person is thinking about an idea of creating a new thing, is thinking about, has an entrepreneurship mindset. It should also be, apart from having an idea, it should also be protected, because it eventually encourages the individual to also indulge in new kind of invention for the future. So it is also important to protect it. And with regard to its recognition, intellectual property also guarantees recognition of that particular product property, which has been clearly protected from other creators, or other from other inventors. And it also ensures material reward for intellectual property. Of course, you're trying to protect your invention, you're trying to protect your innovation, you're trying to protect your product. Of course, it is coupled with a reward associated. It is definitely, intellectual property can never be granted with regard to a copied product, or a product which is already there in the market. The intellectual property is trying to protect genuine and original products only. Now, if I there are various kinds, as I discussed, patents per se talks about only invention. If I come up with a product which has not been introduced in the market, because the theme of the FDP is entrepreneurship skills. So if I think of a product which has not been invented, or which has not been in the market per se, I will try to come up with a new product altogether, catering to the need of invention. That invention is clearly protected under patent. If you talk about a lot of tech startups, a lot of machines, a lot of new idea, all of these are part of patent protection only. It is a technical solution to a technical problem. Majorly, every technical aspect is clearly protected under patents. And if I talk about industrial design, it is an appearance which is clearly protected from other product. An external appearance, maybe if the bottle is clearly, if you design a machine, how the design, how the machine has been clearly designed is being protected under industrial designs. The shape, the pattern, the configuration involved in making that particular product is industrial design. And trademark is associated with a logo of the particular product. For example, you think of coming up with your own startup. If you permit, there are a lot of startups in India have been founded by a lot of professors all across our country. And I will also give you examples of certain professors who came up with good startups, and they also try to name that particular, or the symbolization of their startup is through their logo, or maybe a label that is also protected under trademark. All of these are types and kinds of intellectual property. That logo, or the label, or maybe a slogan which is trying to name, or which is trying to give an identity to your product, or to your invention, is also protected, so that your logo or the name should not be copied by somebody else. Generally, trademark is applied to a manufacture, or maybe a service clearly provided. In order to talk about it, eventually indicates the origin of a particular goods and service. But copyright, for that matter, is not with regard to something which you can, it's not with regard to invention. It is an artistic skill, or maybe a literary skill, which is clearly protected, or a musical creation, or a dramatic creation. Therefore, there are a lot of singers. There are a lot of Amitabh Bachchan has copyrighted his voice per se, and there are a lot of people who write books and they try to copyright their books. And the moment that particular artistic work has come into existence, the work eventually can be protected. And geographical indication is kind of a product which has been recognized, or which has been recognized as per the territorial jurisdiction. It can be identified with an agricultural product, or a natural product, or a manufactured product specifically originating from that particular area. So there are a lot of geographical indication of India is trying to protect a lot of product, and also try to promote those product on the basis of the GI of GI allotted to that particular product. It can also, apart from natural product, the aspect of processing into a special quality, or maybe allotting a unique characteristic to a particular product on the basis of the geographical indication, this particular intellectual property is trying to protect that. Now, if I try to talk about organization in India, all of these, although we have 8 laws, 8 act which tries to clearly protect different intellectual property in India. But if I talk about administrative aspect, Ministry of Commerce, Industry, and Department of Industrial Policy and Promotion, they try to regulate the entire intellectual property. It is the ambit of Government of India. It is there as one ministry, and central government is purely involved. And under that ministry, there is a position called Controller General of Patent, Designs, and Trademark. Controller General have an incredible role to play in order to talk about whether the intellectual property rights have been clearly protected. All the citizens, all the products all the people are trying to protect their product, which has been invented, or maybe an artistic work or literary work which has been clearly coming on the market, clearly protected under intellectual property. All of these is the work of Controller General. He has an upper hand to regulate every right per se with regard to intellectual property. We have under them, we have Patent and Designs Office, which are located in Kolkata, Delhi, Bombay, and Chennai. We have Trademark Registry, where we try to register our particular logo of a product which has been invented. The offices are located in Bombay, Kolkata, Delhi, and Chennai, and Ahmedabad. And geographical indication registry is clearly done in Chennai. And you have patent information system clearly under different organizations. I have given the patent office in Bombay, in Chennai, and in New Delhi, in Kolkata also. But if I talk about the protection, of course, once if you come up with a startup, or if you come up with your own invention, or if you come up with your own book, or maybe a product which is not there in the market per se, it is the intellectual property cannot guarantee the protection till the lifetime, or maybe no infinite duration of the protection. Every protection is being limited under a specific time. So a patent, for that matter, is clearly protected within the aspect of 20 years, and it has been renewed. And there's a process of renewal happening. The process of renewal is, the steps of renewal is clearly given under the Patent Parent Act 1970, and it has been amended in 2005. And if I talk about trademark again is clearly protected. The maximum protection is lifelong, but it is again renewed after every 10 years. It is also the steps of renewal. What will you submit to the trademark registry? There are offices clearly mentioned. What will you submit? How will you submit? How much time will it take to renew your protection of trademark? That is clearly given under 1999, the Parent Act, and it is amended in 2010. The Designs Act, the Industrial Design Act, the maximum protection 15 years, but after 10 years, or maybe after 10 years and then plus 5 years, the renewal can happen, and it is again protected under Parent Act of Designs Act 2000. Then copyright is for 60 years, but copyright differs from country to country. So it can be 60 years maximum protection, and renewal it's not necessary, but definitely once the Copyright Act come into existence, you get protection throughout. Again, a parent act for Copyright Act 57. Then Geographical Indication Act, lifelong the moment the government guarantees that particular product a GI tag. Then in that case, renewal can happen after 10 years, but the maximum protection is lifelong. Renewal just act as the additional protection which the act gives you. Now, if I give you an example, if you can see the screen, you can see a bottle of a soft drink named Coca-Cola. The logo Coca-Cola is an example of a trademark. Only the logo, the way, the calligraphy, how Coca-Cola has been written, that is an aspect of a trademark, which is also clearly protected under an act. Nobody, no company per se, if they come out with another soft drink in the future years, will not be able to take this particular logo, the manner of the logo written. But the shape of the bottle is clearly protected under industrial design. And the patent as in the machines used in order to make a specific soft drink known as Coca-Cola is being clearly protected, so that any other company per se will not be able to use the technology which the Coca-Cola company is taking, because they've already taken a patent protection. And copyright is with regard to the artistic work which is written on the Coca-Cola website. So there's a specific Coca-Cola website, and the text in the database or the artistic work related to any kind of product is clearly protected under copyright. So if you see the one product has been clearly protected under different IPRs, under different intellectual property rights. It can also be trademark because there's a logo given, there's handwriting, there's a calligraphy, the way through which the logo is clearly given. The design of the bottle is clearly protected under industrial design. Then the patent, the technology used in order to make the soft drink is again protected under different another protection called patent. Then you have a copyright also. So one product can be protected under different IPRs. So in the same manner, every startup also, for that matter, it is important for every startup owner to also recognize that not only one intellectual property can try to protect your product, there can be number of intellectual property rights. When you have so many laws altogether, when you have so many protection, there is no harm to take protection with regard to protecting your product through a startup. I have given an example of a fan on the left side of the screen. The technology used in order to move the fan is clearly protected under patent, but the industrial design is trying to protect the design of the fan. In the same manner, geographical indication, the aspect of geographical indication, there are example being Tirupati Laddu has attained geographical indication tag. There are spices which have got GI tag. There are fruits. There are saris. There are apparel which get GI tag, and they get renewed more often. And if you see on the right side, there is a phone kept. The trademark, the Apple logo has a trademark which is also protected under Trademark Act. Then I already discussed the aspect of Coca-Cola, and then I've given example of a GI tag in terms of Kolhapuri chappal, because it is specifically mentioning one territory and the GI tag associated with that territory. Now, if I clearly explain what are patents, patent is an exclusive right which an inventor gets. So that the inventor is trying to prevent the other people not to copy their invention per se. It can be with regard to any kind of technology used. It can be with regard to export or import. For example, if I come up with a tech startup helping the students, maybe in favor of the students, but the technology, the startup was invented by me, the idea was mine. I will try to prevent other people to take away my idea. So I will try to take protection under patent. And they have a territorial jurisdiction, so you can take patent with regard to one nation. If your product goes worldwide, For example, Indian market has already satisfied consuming your particular product, and you want to sell that particular product in the global market. You have to register your particular product with regard to patent in different countries, and there are different regulations, etc. And we have a specific website altogether with regard to patent protection. And patent gives an exclusive monopoly right. It is definitely monopoly right, as in only one person is the owner of that particular patent out of that particular invention required. It is granted by Government of India because it is a clear protection given by the government, and specifically for an invention, for the protector or the inventor of that particular technology or product, etc. And I told you it is a territorial right. If your product is moving its utility service from India to abroad, then you have to take patent protection from the other countries as well. And full disclosure should be made to the Government of India, and there's a term clearly associated. There are patent acts, there are patent rules, there are patent manuals. If I clearly talk about proper law, there are patent lawyers specifically who handle matters with regard to patent protection and patent registration and patent enforcement, specifically expertising in patent. And and the entire act altogether talks about every aspect of the inventive step, and what kind of what kind of product, or what is the characteristics of a particular product or service which gets a protection right of patent. It has to be novel. Novel means it has to be unique. Any product which is already there in the market can never get a protection right. Novelty clearly means any new product getting invented in the market. Therefore, what is the difference between business and entrepreneurship, or maybe a startup? Business and startup, clearly business is selling that particular pen which is already there in the market. But if, for example, if a pen gets into a new technology of calculating the amount of calories which you have taken for the particular day, that is a new technology added to a particular pen which is being sold. The founder is coming up with a startup altogether to come up with something new in the market that has been clearly protected under patent. Then, if I talk about Industrial Design or Designs Act per se, it is an incredible, useful protection which is given to the industry. Apart from invention, apart from a new product, the special appearances, how the product looks, is clearly protected under designs. How the particular product invented by you is different from other product in the market is also differentiated by industrial design. It is Patent is not talking about how it looks externally. It is talking about the particular aspect of its working. But designs act talk about how does it look from the external aspect. And again, industrial design is different from trademark. Trademark is just a logo with regard to a particular product per se, logo which tries to identify your product, not your product. And it is an ornamental aesthetic aspect of a particular product. It can be with reference to shape, it can be with reference to surface, maybe design, or maybe color or textile, or any pattern, or maybe lining. Basically, it is making a particular product attractive enough. It adds to commercial value so that the product can be sold in the market. And no other person should be able to copy the outer external appearance of the particular product which you are inventing. And you also get exclusive rights against unauthorized copying. But of course, if you're trying to copy, you have to seek permission, and there's a specific tenure altogether it gets, and the tenure has to be renewed in a specific period of time. And I've given certain examples of industrial designs, jewelry, maybe how a new chair works, or maybe how a new product or maybe new car is coming into market, or maybe in the aspect of apparel, footwear, etc. How does the product look from outside? Trademark tries to identify a particular product not by the appearance but by its specific logo, which cannot be copied by anybody else. Clearly protected by a logo is generally established through a brand value. It's a brand which you are trying to protect through a specific symbol called logo. It can be a visual symbol. It can be your name, your handwriting, or maybe a specific type of how you name your particular product, to the way you write your product with. It can be with regard to device, or maybe combination of numbers, which numbers or combination of colors you use to identify your particular product. So if I come up with the startup per se, and if I'm designing a product, the technology in order to make that particular product is protected under patent, but the logo of my product is being protected under trademark, and the appearance of the pen is clearly protected under the aspect of designs. Any name which is not unusual for trade to adopt as mark. It is a symbol, it is a symbol, it is a device or a monogram or a shape of the good or for packaging, or maybe a combination of colors used. If you can see, there are a number of logos which I have displayed in my screen. These are clearly protected under the aspect of trademark. And copyright, it is an exclusive protection or description rights given to the creators on their literary work, on their artistic work, so that the other people should not be able to copy. It can be artistic work, can be divided into literary work in terms of books, in terms of novels, in terms of poem, or maybe a play, or maybe a reference work, or maybe newspaper, or maybe any article which you write, any research paper which you write. Or if I talk about computer programs, or maybe a computer language, or maybe database, or any other which you come up. Any in terms of artistic work, it can be divided into films, a musical composition, which these music directors take an aspect of dance or theoretical production. Or if I talk about artistic work, can also be painting, can also be drawing, can be photographs, can be sculptures with sculptors make. It can be an advertisement, it can be a technical drawing, etc. All of these are part of copyright. Uh, and the moment the copyright comes into existence as the work is created, in order to protect the skill, in order to protect the labor used, employed by the creator, in order to produce that particular product, the copyright is eventually granted. Now, if you come up with a startup, startup is a business altogether. Startup, either you will be selling a service, or either you will be selling a product. Whatever subject matter you are indulged in, you need to also protect your subject matter, so that any other person should not be able to copy, or maybe infringe, or maybe takes the rights to the particular product. It is your business, it is your the entrepreneurs work so hard to come up with a new venture called startup, and you don't want to miss, or you don't want to lose your entrepreneurship idea to other person. Instead of, I mean, it is better to protect it. Now, if I talk about copyright, the tenure differs from nation to nation. If I talk about USA or Europe, the tenure is 70 years. If I talk about India, the tenure is 60 years. And in the most countries, the tenure is 50 years. So it differs. And all of these protection is territorial based. So the copyright, where the book written here in India will get protection as per here this law. The book written elsewhere get protection as per the territorial rights or territorial law of India. And if I talk about geographical indication, it is trying to identify an agricultural product, or maybe or a natural product, or maybe a manufactured product. It can be in relation to a territory, and that particular product is trying to signify the originality or origin with regard to a territory. It gives protection to a group of people, or maybe an association involved, in order to produce that particular product, because you need specific skills to make that particular product. Tirupati laddu cannot be made by somebody in North, because it has been the way they make the laddus. It has been uh, um, clearly identified in that part of the territory of India. And of course, GI can never be given to a service. It is majorly given to a manufactured good which is produced or which is processed in that territory itself. With regard to the geographical condition or maybe climatic environment, maybe a specific manufacturing unit which is located in that part of the country only, or maybe a skill which we don't have, only one segment of the people have. It geographical indication, there's word geography attached. So we also have to talk about the place of the origin of that particular product. If you permit me to give example, Darjeeling tea, the tea which tea here, tea which you get it here, or Darjeeling tea, there's vast difference. Or Kanchipuram saris again are clearly protected under GI tag. Kolhapuri chappals, Tirupati laddu, and Nagpur orange, they have got a governmental protection of GI tag. If you give me an example of all of these geographical indication, I there are n number of examples of GI. One being basmati rice. Then, with regard to Darjeeling tea, which is extraordinarily famous. In fact, they have attained a GI tag, and the world knows about the essence of that particular tea. Kanchipuram silk sarees, again, an incredible GI tag of protection given by Government of India to a specific kind of a thread or a textile, which is only produced, manufactured, skill used in order to make that particular product specifically to a region. Alfonso mango, Nagpur orange, these fruits are being clearly, they are famous on the basis of its the place of origin. Therefore, that has been recognized to be sold and to be protected as per their territory only. Kolhapuri chappals, you get it here also, but it is famous in the place of Kolhapuri. Then you have Bikaneri bhujia, and Agra Petha. All of these are examples of GI tag. These are prominent intellectual property rights, but there are other three more intellectual rights which are also connected. Like, for example, there's an act called Semiconductors and Protection Act, and there's an act called Biodiversity and Farmer Rights Protection. These are also certain laws which try to protect. But because the theme is startup, the theme is entrepreneurship, it is definitely it is I will have to do justice with regard to what are startups and how IPR is trying to help. First, let me tell you one thing: there's a difference between startup and there's a difference between business. Of course, it is a part of business only, but special kind of business. If I legally talk about startup, the originality of startup is basically a private limited company only, but it is that private limited company which is very niche in its originality. It is not like a proper company per se, but it is incorporated as a company. It can also be incorporated as LLP, which is limited liability partnership, but we try. Major 99% of startups are incorporated under private limited company because they want a corporate identity. Every business which gets startup, which is started as a startup, wants to have a long leap. They want to convert, they want to establish as a proper company, they want to convert their private company to a public company, and they want to convert their public company as public listed company, and they want to see their name listed in the stock exchange. Therefore, in that manner, they try to come up with their business of startup through a private limited company itself. Fine. Now, because we are thinking of coming up with a business, because we are thinking of coming up with a startup, we need to also protect. That is how IPR plays a very major role in order to protect startups. And it is, and the government of India is trying to come up with, is coming up with maximum benefits with regard to giving IP protection to all of these startups, to all of these young entrepreneurs who've recently entered into the aspect of entrepreneurship. It cannot You cannot clearly say that only young people have a right to start a startup. It is not like that. There are a lot of senior professors from IIT and IIMs. They are pretty senior, but they are young in terms of coming up with their entrepreneurship aspect. So I'm talking about that aspect. So they can't evade the concept of protecting their idea, protecting their product, which can be sold or can also be copied by other people. There is something called current how does IP system works in India? IP system is majorly with regard to IP legislation. I told you there are 8 IP legislation in India. There are certain government schemes and policies. Specifically, if I talk about startup, we have 8 IPR legislation. We also have specific government schemes and policies. Why are governments so interested in helping startups? To be very frank, after 2015, when Startup India policy came into existence in the year 2016, government is trying to help, government is trying to support every kind of startup in extraordinary limit. Extraordinary limit, as in trying to protect a lot of businesses which are incorporated as startup with regard to its finance, with regard to its taxing provisions. Otherwise, they are exempted to pay tax. They're exempted to come up with the labor rights in the initial years. They are exempted with regard to environment rights. They are exempted with regard to a lot of things. So it is startups are like, or young entrepreneurs are like small. It is like a small being, so small individual which has to be nurtured, which has to be protected. Therefore, government is paying more attention to startups in order to protect them and help them grow. So that is why it is the government tries to help you and also try to protect you by telling what are the ways to protect. And also, if for that matter, if you are somewhat lacking in protection, how can you enforce your legal rights? How can you enforce your IP rights per se? If I made this particular pen per se, I have an aspect of protecting this pen. But again, if the protection has been taken away by somebody else by copying this particular pen, I have my right to enforce that in the court. There are n number of schemes which the government of India specifically. Let me be very clear. We have 8 IPR laws which are directly applicable to startup, but there are general laws. But these are specific schemes which only startups get. Or only startups get certain benefits of these particular policies and schemes. We have IPR facilitation centers, which is located in Delhi, Bombay, Kolkata, and Chennai. And IP facilitation centers, I mean, there are centers clearly made. And if you are a startup owner, if you think that your product through startup should also be protected, you directly go, they have helpline centers, you can call them, you can ask. Generally, if it's a big listed company, or if it's a big company, if it is not a startup, they charge a little money in order to take consultation over phone, or maybe but for startups, very mere scheme, very the less amount, less money is clearly taken from startup owners to get registered. Then in that case, you have IPR facilitation by Ministry of Electronics. You have research and development societies and guaranteed institutions clearly made. Then these are initiatives which only government of India try to promote. In order to try to promote startups, they are government of India is trying to help startups through these initiatives. We have patent analysis and management systems, also known as PAMS, and directly ministry is involved in order to protect them. Then we have IP panorama, for which the government is taking extraordinary pain to help them. And we have SIPP plan, which is Startup Intellectual Property Protection. It is also under SIPP plan, is under Startup India policy, which came into existence in 2016. Under policy, these policies are directly, all of these initiatives are government initiatives which are working under Startup India policy only. We have intellectual property policies also, in order to, because startup owners are like small, they have entered entrepreneurship market for the first time, so they have to, it is utterly important for them to understand why it is necessary to protect their particular product. The government wants to create awareness, IPR awareness, in order to increase their outreach program and in order to promote. They are generating a help in order to protect IPR. They want the startup owners to know what are the legal and regulatory framework. They also want you to understand that what is the administration involved, how is the management of intellectual property works. If somebody is infringing your IPR, how to enforce that in the court, because of course your right has been violated, you have to go to the court. How will you do that? You have to also generate the aspect of human capital development per se. Now, if I clearly connect entrepreneurs and IP, it is, I thought that the only aspect which tries to determine entrepreneurs and IP is that you have to first recognize your intellectual property, whether your business needs it or not needs it. If your business wants a protection, what kind of protection? Protection in terms of patent, or protection in terms of copyright, or protection in terms of trademark, or maybe a GI. Anything, the product which you are selling, the service which you are selling, you need to protect it also. You have to recognize which kind of protection, or you need one protection, or you need multiple protections. Apart from recognition, you also have to clearly take steps to protect it by registering it, by coming up with proper registration process, by coming up by going to IP facilitation centers. These are agents which every startups are allotted. But even after taking recognition, even after taking a protection, if there is an exploitation of your intellectual property rights, you have an aspect of going to the court, which is enforcement. Enforcement, as in going to the court, going to the administrative authorities, by telling them that your right has been clearly infringed. Exploitation also means with regard to licensing, with regard to valuation, or with regard to marketing. Your license can also be taken away in a fraudulent manner. Your valuation of product can also be undervaluated. In terms of marketing, also maybe a marketing strategy is being clearly taken, etc. If you have an aspect of going to the court will of course try to, Indian judiciary will try to interpret, or maybe will try to provide you maximum benefit, or the government of India through the process of enforcement will try to help the owners of intellectual property to get proper justice per se. If you try to combine the aspect of recognition and protection, exploitation, and enforcement, you get a competitive advantage. That is how you try to get into the market of competition. And we have an aspect of competition in India. Ultimately, every entrepreneur, every business, every startup have to follow the principles of competition, and we cannot enter into an aspect of unfair competition. We are it is compulsory for us to work with regard to fair competition itself, because ultimately it's a financial market. We are part of a financial system. We are part of a business. We are part of buying and selling for particular product which we are trying to protect. Therefore, we also any step which is clearly missed from the startup owners end have to be also they have to also follow competitive measures involved. Therefore, you combine, you get a competitive advantage, not unfair competition. You again have to keep a tie with regard to how your startup. So by discussing all of these intellectual property rights, I hope I made myself clear enough in talking about what are different kinds of intellectual property and protection rights given to everybody. And I hope I have done justice to the topic allotted to me. Thank you so much.
Thank you so much, ma'am, for your valuable insight and making us clear that how this patent, trademark, and GI Act are working for us. Ma'am, there is a question just a strike when you talked about the that renewal of the patents or GI or copyrights. If in case any of the company forgets to get it renewed, that if they are having a 5 years of time span and they forget to renew their GI tag or the patent or the trademark or the copyright, and any other company step in with the same idea, same concept, and they ask for their trademark or copy or GI tag. So will the company which was actually existing will demolish from the GI tag or the trademark for which other company is coming in up?
In that case, if I talk about the aspect of patent, clearly, if I talk about copyright, the moment an artistic work or literary work have come into existence, then in that case, it has a lifelong application. But if I talk about patent, it is necessary, or other intellectual property, it is favorable, it is necessary to try to protect it. Let me tell you that Government of India, through all of these IP facilitation centers, will continuously remind you, because you are registering your protection. They will continuously remind you over a text, over an email, over a phone call, that it is the time to renew your protection. And if you practically talk about patent over a period of a significant period, it is utterly important to renew your particular product. Otherwise, the other person will try to take the idea and will evolve that idea, taking a parent idea of yours, and will try to make that particular product in a specific manner. So, copyright, once the artistic work have come into existence, there is no need of proper renewal. But for other, it is definitely other people can infringe your rights, can take away your rights, and can revolve and can make their product on the basis of the intellectual right, which you forgot to register or forgot to renew.
Okay. And then from the point of view of the universities, that their research output, how they can be get it patent, or how the intellectual property rights can be applicable in the universities commercializing their research means product or
Now,
software or
in
other
that
things.
aspect, if you talk about artistic work, or maybe a literary work written by professors, or by scholars, research scholars, in the form of research papers, etc., it is a form of copyright. The moment you write it, you get a lifelong protection and lifelong recognition on the basis of your work by your own name. But if you come up with a new idea per se, and if you want to patent, you have to follow, you have to register your patent. There's an online registration happening. You have to convince the patent office that your idea is novel, that your idea is unique, etc. And it should not be copied by anybody else. In that manner, it is definitely important for every academician, if they're coming up with a new idea, to patent it. But in terms of literary work, maybe in the form of book, or maybe in the form of chapters, or maybe in the form of research papers, your aspect of writing is more than enough.
Okay. Thank you so much, ma'am, for the wonderful knowledge and insight. I think participants, you had a very good time knowing about how the patents, copyright, or we can say in short, the intellectual property rights help us to get our things safe. It should not be copied. It should not be taking as a misuse of some other things also. So I would like thank to Dr. Tanvi Sharma, ma'am, for giving us some time
Thank you.
and sharing the knowledge with us.
Thank you.
Participants,
Thank you so much.
thank you, ma'am. Participants, feedback form will be shared on your WhatsApp group, and please stay tuned with us at 2:30 session. We are again going to have a eminent speaker with us who will share some knowledge along with some new ideas, new concepts. Whatever sessions which we are having till now, all these sessions will be having an evaluation sheet. Evaluation test will be there for you, which will be shared with you on 2nd and 3rd of the February. So please stay connected and stay tuned. Have a good day. Thank you.